Good afternoon all. My name is Nick Combis. I'm one of the directors of Vincents Chartered Accountants, and I'll be speaking or presenting in relation to ineffectively Insolvency 101. So what I wish to speak about this afternoon is advising insolvent clients, some practical tips for those in financial difficulty. So I've broken this down into 4 key topic areas. Firstly, I want to speak about the types of insolvency appointments. I also want to raise with you some ethical and reputational considerations. There are some important or topical issues which are, I think, of interest to all, and then I'll just quickly touch on some key stakeholder information. So let's deal with firstly let's deal with the types of insolvency appointments. There is some confusion in Australia as to what the different types of appointments are. Bankruptcy refers to an individual. In America, you hear the word bankruptcy, it refers to corporate entities. Liquidation is in relation to a company. A voluntary administration or deed of company arrangement is in relation to a company. A personal insolvency agreement is for an individual, and receivership can be a company or individual, though predominantly a company. So we have all these different terms, and there's always confusion. People say my company is in receivership when perhaps it's in effect in liquidation. So it's important to understand each of the terms. So bankruptcy for an individual, liquidation for company, voluntary administration and deed of company arrangement for a company, personal insolvency agreement for individual, and receivership can be company or individual, though predominantly company. So quickly to touch on bankruptcy. Bankruptcy can be voluntarily initiated, and that's called a debtor's petition. No court process, simply filling out forms, and a person can voluntarily declare themselves bankrupt, and it can happen very quickly. We're talking a matter of hours, minutes. Bankruptcy can also be initiated through a court process, so that's where a creditor physically sues a debtor, seeks a recovery of money. That's known as a creditor's petition. Now, bankruptcy has a common purposes of effectively providing an equitable distribution of assets to creditors. It also offers protection and rehabilitation to the debtor. The bankruptcy laws also permit an investigation to take place. There are restrictions on individuals in bankruptcy, things like obtaining credit, incurring of further debts, overseas travel, and that's during the bankruptcy period. And there is also benefit to society. Now, a system of personal bankruptcy can provide a benefit to society. In terms of a 2013 World Bank report, it states that bankruptcy serves to reduce or limit wasteful collection costs and diminished value in sales of debtors' assets. It encourages responsible lending to debtors, concentration of losses on more efficient and effective loss distributors, reduced welfare-related costs through illness, crime and unemployment, increase the debtor's capacity to again earn taxable income. It encourages entrepreneurship and enhances stability and predictability in the broader economy and financial system. So there are certainly some key important takes in relation to having a proper system of personal bankrupt insolvency. Liquidations. Similar to bankruptcy, you can have a voluntary liquidation, and that's initiated by resolutions of members and directors, and that's known as a creditor's voluntary liquidation. Liquidation can also be initiated by a court process, and that is by a creditor taking action through the courts seeking to appoint an official liquidation, and that's point 2 on the slides in front of you. Liquidation and the liquidation legislation, which is the Corporations Act, essentially mirrors the purposes of bankruptcy. So again, we're looking for an equitable distribution of assets between the relevant stakeholders. Obviously permitting an investigation of the examinable affairs of the company and its lead up into insolvency take place. And again, it offers the benefit to society. In the case of a liquidation, I think the benefit to society is by preventing an insolvent company from continuing to trade and incur debts where those debts may not be payable in the future. In a liquidation, of course, it is a terminal event and we'll never see the company resurrected again. Voluntary administration and deed of company arrangement. The voluntary administration regime allows a company and creditors flexible alternatives to deal with a company's affairs. So the aim of a voluntary administration is to allow a company in financial distress time to develop and implement a restructuring plan with creditors, or at least allow time to plan for an orderly asset sale through liquidation. So what happens in a voluntary administration is control of the company is handed over to a qualified insolvency practitioner in a prompt and economical fashion. There is no court process in a voluntary administration. It is done via meetings with creditors. So what ultimately is trying to be achieved is a process whereby the administrator on behalf of the company meets with creditors, a proposal for some sort of orderly sale of assets or a salvage plan to enable the company to continue to operate gets put to creditors. Creditors vote on the future of the company and it is in creditors' hands whether the proposal for a deed of company arrangement is accepted or not. So creditors, it is a creditor-driven process, not a court-driven process. Now, the voluntary administration regime was introduced in Australia in 1993. There has been modifications and evolutions to that process, and in my opinion, it's certainly a valuable tool when dealing with companies in financial difficulty. A personal insolvency agreement is an individual process which is akin to a voluntary administration. So we're looking for an arrangement for an individual to avoid bankruptcy, but nevertheless to meet his or her obligations to creditors. So we're looking for a process that allows a debtor to come to a formal arrangement to discharge his or her debts with obviously less cumbersome or onerous obligations than applies in a bankruptcy situation. The law in relation to Part 10 is designed to encourage flexible arrangements between debtors and creditors under the provisions of the Bankruptcy Act. Again, it is a creditor-driven process. Creditors vote on the proposal and they are the drivers of the proposal. And now over the years there's been some issues with Part 10s in relation to integrity. There's been some increased disclosure requirements, independence of appointees and information to stakeholders has evolved and developed. There was a time when it was considered that Part 10s were taken advantage of by certain high net wealth individuals, and there's been a raft of changes, modifications to the Bankruptcy Act, which should give all stakeholders some confidence in the process under Part 10. The number of Part 10s has dropped off over the last few years. That's probably a reflection of the changing nature of personal insolvency, the tighter restrictions, the increased independence and required statutory information to stakeholders. So, but certainly Part 10s are still a valuable tool in any system of personal insolvency. Finally, to touch on receivership, as previously indicated, most commonly applies to corporations, where a secured creditor appoints a receiver pursuant to default under some type of security document. In the old days, and being of some age, I can talk about the old days, we used to have a registered equitable mortgage or a fixed and floating charge. Currently, we now have under the PPSA an all PAP, all present and after acquired property. Receivership's largely a creature of statute. Now, the purpose of the appointment of a receiver is to take control of property or get property in order to protect the rights of the party entitled to the property. That party, of course, has a registered mortgage or security. As I previously indicated, under the new PPSA legislation, it's known as ALLPAP. So the role of a receiver, unlike other appointees who deal with all creditors, a receiver only is really answerable to its appointee, to the secured creditor. It doesn't have a duty or obligation to deal with the unsecured debts. Therefore, you might have situations where you have a receiver appointed, and you may also have a voluntary administrator appointed or a liquidator appointed. The receiver is dealing with the secured property and the secured creditor, and the liquidator or the voluntary administrator is dealing with the unsecured creditors. And they do also work closely in with each other. I'll now move to some ethical and reputational considerations. Obviously, in insolvency situations, there are tensions from various stakeholders, particularly where there's a dwindling pool of assets. You have the emotions or the tensions of a debtor or a director of a company who's seen their business fail. You also have creditors who might have significant debts outstanding, and they're obviously very uptight about the recoverability of their debts. Both directors and individuals have their own duties and obligations under the respective legislations, and they're obviously keen to protect the reputation of their business. One of the reasons is that obviously you don't want to tarnish the business, because if you tarnish the business, then you potentially tarnish the recoverability that can be made from the sale as a going concern of a business or certain types of assets. Therefore, it's always imperative that where you have an individual or a company in some sort of financial distress, that professional advice should be sought to assist in determining the options available. Now, the earlier individuals do consult, the more options that are likely to be available to them to either stave off any form of external administration and also consider ways of restructuring. So it is critically important that professional advice be sought in a timely fashion. Obviously, that advice should be from a skilled and independent professional, and if necessary, that person can then exercise some form of external administration. One of the formal insolvency appointments I previously mentioned, comply with statutory obligations, realise assets, and maximise the return for all stakeholders. Now, as liquidators or as trustees in bankruptcy or as voluntary administrators, registration and specific requirements must be met. Most practitioners are chartered accountants or certified practicing accountants, and we are certainly bound by relevant codes of conduct. Chartered Accountants Australia and New Zealand have sets of regulations for chartered accountants. ARETA, which is the Australian Restructuring, Insolvency and Turnaround Association, also has guidelines, codes of conduct for its practitioners. And, you know, without going into great detail, the practitioners need to be independent, both real and perceived, impartial, and obviously provide adequate disclosure of any pre-appointment meetings, consultations, advice, and any remuneration received in that regard. Turning to some topical issues. Those of you who closely follow the press would no doubt have seen that the media has reported that applications made by the Australian Taxation Office to wind up companies, place them into liquidation in the months of April and May of 2015 equaled the numbers of applications made in the prior 12 months. So that is a significant ramp up by the Australian Taxation Office in seeking to wind up companies. There could be a number of reasons for that. Whilst none have been publicly disclosed by the Australian Taxation Office, I propose to offer a number of reasons. Firstly, I think that for a number of years the Australian Taxation Office has been quite lax in pursuing debtors or allowing them to drag out their obligations, and I think the time has come, or they've ruled a line in the sand and they've basically indicated we are no longer going to allow parties extended terms. I believe another reason is that there is some pressure on consolidated revenue, and obviously they're looking to call in some additional monies. And I think another reason which perhaps doesn't get a lot of attention is that the ATO is probably the second banker for most companies and individuals. What I mean by that is where they are short of funds, it is the first creditor to not get paid, and hence it becomes a quasi-banker for a lot of companies and individuals. And I think the ATO has taken a harder view that where companies stop paying their debts, then the risk is that they will then start falling behind creditors' debts, and by taking early action to wind up, they are in effect protecting creditors from losing out monies. Now, whether you accept those or not, the reality is that the ATO has become a much more aggressive creditor, and the numbers clearly show that over April and May they were quite high. June numbers to date, from what I have seen, are also going to be quite high, so that trend I think will continue. Now, some of the key warning signs from the ATO: for a company, they'll issue a statutory creditor's demand, which is a 21-day demand, and for an individual, they'll seek a judgment and then perhaps seek to enforce the judgment by way of bankruptcy notice. So these are the documents, if you receive them or if your clients receive them, or you're informed that a client is receiving these types of documents, then it is time to seek some advice pretty quickly, because the action has certainly escalated. So obviously, what should I do if I have a taxation debt? Communication with the ATO is vitally important. Whether that's done directly or via your advisor, it certainly should be done. And if you're giving the ATO relevant and up-to-date information, they certainly will work with you. Where they will simply proceed to wind you up is where you ignore their requests for information, you fail to meet deadlines, you fail to meet proposal for repayment that you've put in place. So when we're discussing with the ATO payment proposals, I think it's very important to try to under-promise and over-deliver. If we over-promise and under-deliver, that will then probably get the ATO offside for us. Another area with respect to the ATO that's been quite topical of late is director penalty notices. Now, just to give a bit of history of what the director penalty notices are, prior to 1993, the ATO was a priority creditor. They gave up their priority, and in lieu of that, they received some additional powers to hold directors of companies personally liable for taxation debts not paid by companies. So it's a pretty draconian power. So the ATO can issue a notice, and they will seek to recover any unremitted PAYG instalments or any unremitted superannuation contributions. Now, there are two types of notices, what I call the old style and the new or the lockdown style. The old style notice basically provides that if you are lodging all your ATO lodgements on time or within 90 days of their due date, you will get an old style notice which gives you 21 days from receipt of a notice to place a company in liquidation, place a company administration, pay the debt or compromise the debt. So you do have a get out of jail. On the new or the lockdown penalty notices, once your lodgements are greater than 90 days overdue, there is an automatic liability and there is no ability to get out of that notice. And in other words, the notice and the penalty attaches to the director. The reason those lockdown notices came about was that a number of advisors used to indicate to clients, don't lodge your BASs, the ATO won't know how much you're owed, therefore they can't come after you. And they basically hit that on the head with these new type of notices. So compliance is vitally important, and compliance is also vitally important if you are trying to negotiate a resolution with the Australian Taxation Office. So apathy and avoidance, burying your head in the sand, is certainly not a solution and will only create significant issues for a director of a company personally and of course for the company itself. Another topical issue is with respect to the Australian Securities Commission is Phoenix activity. So what Phoenix activity refers to the transfer of assets or a business from an insolvent entity to another, leaving creditors with no prospect of return while essentially the same business continues. So what we have is a business closing today, opens up tomorrow, new name, same employees, same premises, but of course in a new name, so the creditors of the old company have no recovery. Estimated to cost the Australian economy in excess of $2 billion per year. I would say that's probably understating the cost to the economy and therefore obviously a significant area of focus for the ASIC. So the characteristics of a Phoenix are a situation where a company cannot pay its debts, the company acts in a way to deny unsecured creditors access to company assets, so we're transferring to a new entity. Another company trades from the former business with the same assets and directors. I hate to say it, but I suspect a lot of the listeners out there would have certainly come across such situations. So what's ASIC doing in relation to that? Well, they've got assistance to liquidators in obtaining books and records. They fund liquidators for investigations into offences, and obviously the liquidators report the offences to ASIC, who then take action. ASIC has the ability to disqualify directors from managing companies, and ASIC will certainly prosecute directors for offences, which includes Phoenix activities. So I suppose there is somewhat of a partnership between the insolvency profession and ASIC in order to try to stamp out and limit the effects of Phoenix activity on creditors. Just want to quickly touch on some information with respect to key stakeholders. So employees are obviously a vital asset in any business. Where you're trying to sell a business as a going concern, a key resource is your employees. If you lose your employees, you've effectively lost the ability to sell the business as a going concern. So it is vitally important that the employees be well informed and provided with necessary information to give them comfort that they will be protected. The employee entitlements do rank in priority over unsecured creditors by law. External administrators, whether they be in a personal situation or a corporate situation, can come in, continue trading a business, rehire employees, and the external administrators then have personal liability to pay ongoing entitlements and expenses. In the case of an entity or an individual failing, there is a government scheme known as Fair Entitlement Guarantee, which will fund employee entitlements. It will fund all outstanding wages, all outstanding annual leave, long service leave, payments in lieu of notice, and redundancy capped at 16 weeks. So the only entitlement that fund won't pay is compulsory superannuation contributions. And I obviously recommend that employees be kept well abreast of situations, regular meetings with them, and I think if you do that, you will have the support of your employee base. Other key stakeholders in any form of external administration are secured creditors. Their rights are largely unaffected by insolvency, and the reason that is because they have security and they will rely on their collateral security, whether it be an all-PAT, or as was previously known as a fixed and floating charge, chattel mortgages, and the like. So secured creditors can repossess their assets, and they can certainly appoint receivers during other forms of external administration if security provides for it. So if a company goes into liquidation and there is a creditor who has security over specific assets, they can still appoint a receiver to protect themselves over those specific assets. An external administrator will always work with secured creditors to realise assets where their equity exists for the benefit of all creditors, and the external administrators can also act as an agent for the secured creditor. So in effect, you're working on the one hand for all the creditors, but on the other hand, you're working for a secured creditor to deal with or realise its specific assets as well. Finally, the other and probably the most important key stakeholders are the largest group, which is the unsecured creditors and contributories or shareholders. The rights of unsecured creditors are significantly affected upon insolvency. So upon any insolvency event, unsecured creditors cannot take any further action against a debtor or a company without leave of the court. And that's part of the insolvency regime. If you have shares in a listed company and that goes into some form of insolvency, there is a restriction on transfers of shares. Shareholders are generally the last cab in the rank, and generally they get notices from a liquidator saying that the shares are worthless and they claim a capital loss, as the case may be. It's important to note that external administrators, liquidators, trustees and bankruptcies are accountable to creditors and contributories as a whole. And where they are dissatisfied, they can apply to court to have actions or conduct reviewed, and they can certainly also make reports to the relevant regulators, whether they be ASIC in relation to companies or AFSA, the Australian Financial Securities Authority, with respect to individuals. External administrators have obligations to issue reports and convene meeting of creditors, and dissatisfied creditors, as I previously indicated, can seek the replacement of appointee, and they can also govern their approval for certain investigations or legal actions as well. So we are trying to see both legislations, the corporate and the personal, push the creditor participation and make it a creditor-driven process. The topics I discussed are quite complex, and I just quickly touched on a few. I'm certainly happy to assist any party or take any questions either by telephone or email, where the case may be. But that's just a quick snapshot of some real topical issues that I think covers the bare basics and understanding where insolvency currently stands at the moment. So in conclusion, if the client takes the initiative, comes and seeks advice early, it certainly improves the chances of a genuine restructure or return to creditors. I cannot urge enough clients to seek advice of qualified insolvency practitioners regarding the options available, and it's also very important to discuss costs in particular circumstances. I think it's also important when the client gets that advice that they be aware of their duties and obligations and potential offences both prior to and after appointment, as well as be cautious or wary of entering into transactions in the period immediately prior to some form of external administration, which may then be declared voidable by an external administrator. And finally, and it is very important to note that any transactions or conduct prior to appointment will be investigated and reported to the respective regulators by the external appointee. And finally, the external appointee's conduct can similarly be reported to the respective regulators for review. So creditors, secured creditors, employees, effectively all relevant stakeholders have that ability to have the conduct of any external administrator reviewed. And as no doubt you've seen, there are a number of queries going on with respect to conduct of insolvency practitioners. I think that pretty much concludes my time. I'd just like to thank all for attending this afternoon, and just to repeat, my name is Nick Combis, and I can be contacted through the Vincents Chartered Accountants website, and I'm certainly available to have meeting or discussion with clients with respect to any issues they may have going forward. I'd like to thank you all for your patience and attendance this afternoon, and I hope that everyone has taken out something valuable from this afternoon's presentation. Thank you.